Okay. There you go.
Very good. Council, this is DC 19-18966, Laura Munson and Matt Munson versus Cornerstone Contracting LLC. Council, this proceeding is being conducted over the Zoom platform, being done remotely in order to comply with the open courts provisions of the Texas Constitution. This proceeding is being broadcast on the court's YouTube channel and is therefore open to the public as far as observing this proceeding. Because we are broadcasting on YouTube and because we're handling this over Zoom, it's possible that one or more parties might try to create a record using the Zoom video file or the YouTube video file. And I have to advise that that is not permitted. There is one record and one record only that comes out of proceedings in the 95th District Court, absent an additional order of the court. And that is the record maintained by the official court reporter of the 95th District Court. That's Ms. Rouse, who is here and who will report this proceeding. Can I get introductions of counsel, starting with Mr. Hammock?
Good afternoon, Your Honor. Dave Hammock with Hallett and Perrin on behalf of the plaintiff, Matt and Laura Munson.
And Mr. Cartwright.
Yes, sir. Aaron Cartwright on behalf of the defendant, Cornerstone Contracting.
Welcome both of you to the 95th District Court. And for the record, the court issued or signed a default judgment on January 29, 2020 in favor of plaintiffs Laura Munson and Matt Munson against Cornerstone Contracting. And what we have before us today is a motion to compel post-judgment discovery, right, counsel?
Yes, Your Honor.
All right. I have a question for you, Mr. Hammock, and I'm intrigued because I don't know the answer to this.
Yes, Your Honor.
You're asking ultimately that I order Mr. Yates to reply to this discovery.
Yes, Your Honor.
Is that correct?
That's correct, Your Honor.
Now, I understand him to be the principal of the defendant LLC, or the sole member, I guess is his technical term. But what basis do I have to order him personally to respond to this? And I'm intrigued. I'm intrigued because I don't know. But is there some rule or case law I'm not aware of that allows me to take post-judgment discovery directed to the defendant and order somebody else to answer it?
It's a good question, Your Honor. The case law is cited in the brief, and it stands for the principle, and I'll bring it up real quick. I'll give you the case site. It's the In Re Merrill Lynch Trust case, 2 Southwest 3rd, 185.
I'm sorry, you're cutting out.
You are cutting out.
I'll move my computer closer to me. Is that better?
That's much better.
Oh, great, great. The In Re Merrill Lynch Trust case, 235 Southwest 3rd, 185. Stands for the principle that companies can only act through their agents. And the purpose of the request, Your Honor, was simply put, is to get Cornerstone's attention, to name Mr. Yates individually, solely in his capacity as the principal of Cornerstone. Have him cause his LLC to respond fully, to these discovery requests. Your Honor, about 90 minutes ago, we started getting in for the first time in this case substantive discovery responses to the requests that we first served back in April. And unfortunately, it still appears, obviously we haven't had time to sit down and do a detailed analysis of what we got. But at first glance, it appears that an order and attorney's fees are still necessary. Cartwright and I were just visiting for a moment before the hearing. We are still missing their substantive responses to the second request for production. The remainder of the responses that we got are frequently the phrase will supplement, incomplete interrogatory responses. There's no signatures, there's no verifications, and so forth. Troublingly, it appears that there was about $100,000 in their Bank of America, in Cornerstone's Bank of America account right at the time that the court entered the default judgment, and that account has since been emptied. Equally troubling,
all of which may give you great avenues to pursue. But does that In Re Merrill Lynch Trust Company FSB case provide that I can hold the member of an LLC personally responsible for responding to discovery propounded to the LLC?
in the manner that you asked, Your Honor, no, it doesn't stand directly for that proposition.
I mean, I do understand the concept that a company can only act through the action of its agents, and I understand that. I also understand you could probably subpoena Mr. Yates directly and order him to do so. But I'm hesitant to sign an order ordering him directly to answer that unless I know of some authority that says I can do that.
I understand, Your Honor.
Mr. Cartwright, you're sending some responses?
Yes, Your Honor. So I've mentioned this to counsel beforehand, immediately before this hearing, as well as to the prior counsel at Hallett Perrin earlier this year, which is that getting these discovery responses is the equivalent of pulling teeth. And, I absolutely take, full responsibility for the fact that we have been extremely slow in responding. I'm counsel of record, so that one falls on me. But I have provided every ounce of information that I have as of right now. And yes, I am still missing plaintiff's second request for production. But we've propounded basically the bank account information for all bank accounts so that they have name, address, routing number, and last four. So they're able to draft a turnover order and a subpoena to the bank for any and all funds that are in there. They have Taylor Yates's personal phone number. If I have a subpoena to, turn Taylor over for a deposition, I'm thinking he should respond to that one. I hope.
Well, let's hold on here. Yeah, this starts off with I'm having difficulty getting stuff from my client. I mean, basically is what I heard you just say. Well, there is an easy solution, and that is to order your client to show up, and I'll do this. Order your client to show up at the courthouse with all the company financial documents, all of them. I mean, I can do that. I've got a judgment that this court is entitled to use every means in my arsenal to see that it is complied with. Now, is there a reason why I shouldn't order your client to show up in court with every financial document that your client has?
I will go back to my client and address the court's, express the court's frustration to them directly and get more information from them in compliance with discovery requests.
I think that's a really good idea. Mr. Hammack, here's what I'm proposing.
Yes, Your Honor.
Why don't we reconvene on Why don't we reconvene on the afternoon of Tuesday, December 15, maybe at 2:15 in the afternoon. And you might have an opportunity to revise your motion if need be, and certainly revise the order to give me relief that I can sign on. But in the interim, maybe Mr. Cartwright's clients will be a little more amenable to complying with appropriate court-ordered process in the interim.
Would Your Honor prefer to take up the issue of the attorney's fees requested by our motion at the 12:15 reconvening?
Yeah, I think so. I think so.
All right, Your Honor.
Because how they comply between now and then may greatly impact how much of a sanction needs to be put on them.
If I may, Your Honor, the only point that I wish to raise then just at now was that in correspondence with opposing counsel, he confirmed that he has had at least some of these materials and information in his possession from his client as early as July of 2020. And then when we conferred on this motion, he had, I think the phrase he used was answers to virtually all of our questions, and had found additional information that we would probably want. So, but with that in mind, Your Honor, we're happy to take it.
All right. Well, Mr. Cartwright, what do you say about that?
I say that like I said, it falls on me to provide that information to them. I knew that when I had that information that it was insufficient and that it was not in compliance with discovery requests. So I held on to it because it didn't even have the bank account information in it that I've now provided. But again, that does fall on me.
Okay. Mr. Hammock, we'll take it up at the appropriate time on the 15th. I'm Mr. Cartwright. I'm doing this large part because I think your client, after some talking to, might get a little serious about complying with the post-judgment discovery, and I'd rather have that than be holding people in contempt or having to sanction them if possible. I'd much rather have them comply with the discovery and have this judgment be paid, especially when I hear that there were at sometime since the judgment has existed, there was a significant sum of money in an operating bank account. Sounds like this judgment probably should have been satisfied some time ago. But
both of that account information has been provided to plaintiff's counsel
as of today.
Yes, Your Honor.
All right. 2:30 on December 15. We'll pick this up and address this a little bit further.
Your Honor, would you prefer 2:15 or 2:30? We discussed.
Oh, what did I just say? What's your preference?
Either's fine, Your Honor. Let's say 2:30. How about that?
Let's say 2:30.
All right. Thank you, Your Honor.
Mr. Cartwright, get on your client and get that information to Mr. Hammock immediately. It's
yes,
my
Your Honor.
suggestion to you.
Yes, Your Honor. That will happen.
Very good.
All right.
Y'all are excused.
Thank you, Your Honor.
Your Honor.
All right.
Afternoon, Judge. Mr. Rouse.
Oh, hello. I didn't see anybody else. Hello, Mr. Rouse.
I'm bored listening in.
I actually, my wife will tell, I would have been a fantastic attorney. I went into sales. I am fascinated with law. I always have been. I actually have to brush my wife up on the law a lot of times.
Okay.
I don't have to know all that. I just have to know how to take it down. Oh, goodness. So that's all we have for today. And then,
That is all we have for today. And we've got still, I think, one tomorrow afternoon.
okay, nothing in the morning. I hadn't even looked yet.
No, we had something in the morning. I asked Karen to move it and they actually, we now have 2 in the afternoon. All right. I'm going to be out tomorrow morning. So,
Yes, sir.
but, all right, 3 o'clock. Yeah. We've got two small things tomorrow afternoon.
Sorry.
Yes, sir.
Well, you all have a good afternoon.
Question. Can I ask you a question real quick, Judge?
You may.
Have you heard, has there any like words on the grapevine of anything that could potentially come up for you after January 1?